Okay. Good afternoon, everyone. Welcome to our workshop entitled How to Be a Trustee. We are so happy that you've joined us today, and we're excited to provide you with some exclusive information and resources that will give you a deeper understanding of us and our services here at ClinkScales. My name is Emily, and I'm the marketing director here at ClinkScales Elder Law Practice. And we have our main office located in Hayes, and we also have our other office in Wichita, and we do serve clients throughout the entire state of Kansas. So I would like to go ahead and invite you all to ask any questions that you have in the chat box that's located at the bottom of your screen. And then Adam will address those questions or concerns that you may have at the end of the presentation. So without any further ado, I'm just going to go ahead and hand it over to our attorney, Adam Dees, to get us started this afternoon.
Well, good afternoon. Thanks for waiting a few minutes for us to get started. We're wanting to make sure that we have everybody here. As Emily said, my name's Adam Dees. I'm one of the attorneys here with ClinkScales Elder Law, and we'll be talking a little bit more about my story as we get into this. But we're here today to talk about how to be a trustee without starting a family fight. I think that is a concern that we hear about a lot in the news, and that a lot of families that I talk with are want to avoid. And so we put this together for that. So this afternoon, you're going to discover how to maintain family relationships through the process after somebody dies and through the trust administration process, how to be transparent, ways to protect your family from dishonest creditors, ways to limit or eliminate taxes and estate recovery if Medicaid's an issue, and paying for nursing home is an issue, and then some simple and legal ways to transfer resources. Excuse me. Since we do have everybody on, if you could just put in the chat like a thumbs up or an okay, just so that I know that you can hear me and that we are good to go, that would be awesome. So this is for you if you want to keep your privacy and your family values that, if you want to avoid the probate process, if you're a trustee, you might be a trustee in the future, you're thinking about setting up a trust for yourself or your family and kind of what that means. You're worried about taxes, worried about preserving a legacy, concerned about estate recovery, long-term care costs, nursing home costs at $10,000 a month. You got a family business or a farm or something else that you want to make sure stays in the family. Oh, good. Looks like we've got lots of thumbs up and people saying that they can hear, so we are good to go. So this is not for you if your family is planning on not having a plan, and we'll kind of talk about what that looks like. I know last week or a couple of weeks ago we sent out a daily email talking about what happened or is happening to a family, a farming family that didn't have a plan, and they're going to go through the probate process. But if you're here and you have a trust, then you want to do that planning, then this is for you. If you want your family to go through probate, this is not for you, but if you want to avoid the probate process, this is a conversation we can have. If you don't want to know about the important parts of being a trustee, then again, you don't need to be here. And if as a trustee, you're okay with, not knowing what your responsibilities are, your obligations, how to go about being a good trustee, then this is not for you. The other thing is I know we give this presentation every year about the same time. And we do this because we seem to see a lot of families gather at Thanksgiving, at Christmas to have conversations about pre-planning and those types of things. And so that's why we find that it's just kind of a timely topic at this point. I do see that we have some people who have attended before, and we've got some new faces, which is always awesome. We're not going to really have any new information because fortunately the trust administration process, the actual process, hasn't changed a whole lot. But if you want to have some reminders about kind of what that looks like, or just a refresher of what that looks like, and also I see some families that were in the middle of that process, so you'll probably recognize some of the timeframes that we're talking about here and kind of how everything lines up. So, so trust administration for you again is if you don't want court involvement, that's kind of the number one. If you want something that's customization, you want privacy, you're ready to pre-plan because this does involve some pre-planning, and then you want to have some flexibility and contingencies along the way, then that's really where the trust administration process comes in and can be really helpful for folks. So, I want you to close your eyes and just kind of wave a magic wand. And at the end of our time, know that your family's wishes are going to be followed, that we're going to protect your family's legacy, that we're not going to lose property because of governmental taxes. Don't have to worry about losing property to long term care costs or estate recovery, again, with the proper planning. And then having peace of mind that everything is complete and correct and done appropriately. So I like to start with a story. This is JC. He had family spread out all across Kansas. There were multiple portions of real property that were being distributed. There were about 6 beneficiaries. And so he said, look, I need help communicating. I need help rounding all of this up. I need to make sure that, everybody is kept informed and the process goes smoothly. And after he went through our process, he says, I highly recommend Clinkscale's elder law practice. Clinkscale's made me feel like things were done right and on time, made me feel comfortable and at ease. So many of you know us, but for those of you who don't, who are we? We're an elder law firm. We focus on helping families preserve and protect their dignity, health, finances, and legacy. We have practices throughout Kansas with offices in Wichita, Hayes. We began in 1983. We're celebrating our 41st year. We switched over to doing just elder law and working with, end of life concerns and care concerns in 2004. So we've been doing that for the last 20 years. You can see these are the 4 attorneys we have. There's myself, Randy Clinkscales, the founder, Jennifer Walters, who focuses on our Medicaid planning, crisis cases, and Brandon Beaker, who's our attorney in our Wichita office. So who am I? So I've been an attorney since 2011. I know I don't look old enough to have been an attorney for the last 14 years, but I am. I've been an elder law attorney since 2017, focusing on people with aging and chronic care issues, protection of assets from long-term care costs, estate planning, Medicaid planning, and also the estate and trust administration after someone is deceased. I'm a certified elder law attorney. I'm part of the National Elder Law Foundation. And for the last 3 years, I've been a rising star, which is voted on by your peers for folks who are under the age of 40. I'm not going to be under the age of 40 for too much longer, but we won't let you know how soon that big 40 is coming up. Again, I'm a member of the National Academy of Elder Law Attorneys, Life Care Planning Law Firm Associations, which really focuses on getting good care as we age or we deal with chronic illnesses with like dementia, Alzheimer's, Parkinson's, but any chronic illness. And then the National Elder Law Foundation, which you have to go through a test and a vetting process. So this is my family. It's my wife, Alyssa. She's a 3rd grade teacher up at Wilson Elementary School here in Hayes. Kay is my oldest. She is a freshman at Fort Hays State, studying biology with a minor in chemistry. So she's taking on things that I don't even get. Hopefully looking to become a veterinarian. Rachel is 12. She's a middle schooler. She loves cheerleading, gymnastics, and hanging out. And then our 2 dogs, Simon and Bridget, we adopted during the pandemic and just love her. She's a bundle of joy. So why am I so passionate about making this transition easy for families? Well, I was inspired by my grandfather. He was a United Methodist pastor. Around this time of year, you can imagine he would don a red suit and a cap and black cowboy boots, and he would be Santa Claus for nursing homes, for churches, for parties and gatherings. And so this is really a special time with me. He passed shortly about a year after I transitioned to being an elder law attorney. He had Parkinson's disease, and when I was a general practicing attorney, my grandmother called me and said, "Hey, how do we work through him having Parkinson's disease?" And I said that, I really don't know as a general practicing attorney. And so that's when I shifted my focus to elder law and to working through these things and a part of that transitioning resources to the next generation. So, but what I learned from him is that family is first, and trying to keep families together and build those legacies is appropriate. I also learned something very, very important from his work as a minister, and that's everybody grieves in their own way. And we find that when people have chronic illnesses, when people have when people pass away, everybody has a different way that they grieve, and that can really impact the trust administration process. Some people, want to move things quickly. Some people want to have that time to grieve, and I just find that you never know. You can guess, you can surmise, but you never know how that grief is going to play out in different ways. But we also know that transparency and openness are the keys when doing this, and more importantly, having a plan and a guide works. If you're at this trust administration process webinar, then probably there's a trust out there, or you're thinking about the trust, and it's really that trust that is the plan and is the guide, is kind of a roadmap to what happens. So again, Kevin was another person that we helped through the trust administration process. Again, you did everything we asked for and more. My experience was wonderful. You gave me peace of mind, which helped the whole family through this difficult time. Thank you for all you do. So what I want you to know is that your family can have a smooth transition that protects your family's legacy and maintains your family's relationships. And I think that the trust administration process and going through that can be integral to that, because we don't have to deal with courts. We don't have to deal with outside entities. It's just all within the family, and we can move forward. So today we're going to discover kind of the three key things: the importance of keeping beneficiaries appropriately informed, hidden dangers when going through the trust administration when dealing with creditors and Medicaid, and then what you need to know about the right time to distribute resources after someone's passing. And there's some time frames that we're going to go through that talk about that. So if you do have questions as we go through this, I'm happy to answer those and talk through those. You can just put them in the chat box. I know that we had some folks already say that they could hear me in the chat box. So as we're going through, if you got questions, just add them there, and we can talk through those. So number one, why should we keep beneficiaries informed? Well, first one is it's required by law. Kansas statutes specifically say that you have to keep beneficiaries informed. Now, there are certain times and not necessarily limits, but there's an economical way to do that. But by keeping them informed, it usually limits the numbers of questions and can actually speed up the process. So let me talk about a situation where someone didn't keep somebody informed. So Nelson was the executor. This is the estate of Nelson. His brother was the executor of his estate. There were several beneficiaries. He ended up keeping records on scraps of paper, napkins, envelopes, didn't ever provide a final accounting or a full accounting to the court. Notice that this is a probate case, but there wasn't a formal accounting that was done that would, meet those requirements. And the court found that he needed to pay about $9,000 into the estate for poor record keeping. So again, it's just really important to keep those records and keep people informed. Here's the statute, KSA 58A 813. It says they have the duty to keep beneficiaries reasonably informed, promptly respond to qualified beneficiaries' requests for information, provide copies of the trust, provide a report for every year that beneficiaries that actually receive a distribution. Okay, how do you do that? Well, first of all, you start by saying, hey, I'm the trustee. Send a copy of the trust. Usually we talk with folks about every month, 6 weeks, and give periodic updates. They may be formal, they may be informal. Provide the beneficiaries with an inventory as of the date of the person's death. And then having a trusted guide to help you as those questions come up is really important. No beneficiary that I know of complained about having too much information. And the nice thing about when you're doing these things, when you're talking to folks, is that it generally limits questions and speed up the process. So part of that is, hey, instead of the beneficiary is reaching out to you and saying, where are things at? You're reaching out to them saying, hey, this is where we're at, and giving those updates. It builds trust, so there are fewer questions at the end. It may encourage beneficiaries to waive some time limits. So Kim has asked a really good question, and that's, when do these rules apply? Do these rules apply while someone is alive, or do these rules apply after someone is deceased? So the context that we're talking about it is that the person who set up the trust is deceased. So this is really after somebody's death. This is not while somebody is alive. So like my parents have a trust. They are both alive. They are the trustees of their trust right now. This doesn't apply until after they would be deceased. So, Kim, let me know if that was helpful and if that answered your question. Um, but again, doing this can really limit questions and speed up the process. There's a family that I've been working with that kept that kept the beneficiaries informed. We were able to sit down at the end of the trust administration process. They were able to say, "Hey, we've gotten everything we needed to know about this. Can we go ahead and make distributions?" And so they waived some time frames that allowed us to uh, speed up that process. Kim had a follow-up question about whether or not about if dementia is involved uh, before someone passes away. And again, Kim, that just depends on how much dementia is involved, whether that person is in nursing home setting, if that person is at home, if we've got a doctor's letters that say they don't have capacity, those types of things. That's really the subject of a different presentation we give, and that's called How Doing Dementia Differently. So these things, this again is focusing on after someone has passed away. All right, so now that we know the importance and the ability to, the ways that we can keep beneficiaries up to date, let's kind of talk about the hidden dangers of creditors, the IRS, and estate recovery. And I know that these are really hot topics when I'm talking um, to families, especially for those who have been on Medicaid or have needed nursing home care. So the first one is hidden dangers of creditors. And this isn't actually a creditor situation, but in the estate of Solzman, there was a probate that was completed. Again, we didn't have a trust, so it wasn't private. There was a probate completed. It was he didn't have a will. Everything was public, and they published notice saying, hey, if there are any unknown creditors or any unknown heirs or anybody that may have some type of claim, you've got so much time to raise your hand and say, hey, I need to be paid. Well, 2 years after the estate was closed, a alleged unknown beneficiary who said that she was the sole daughter of Mr. Solzman um, raised her hand and said, well, I should have received everything. And it was quite the estate. And two or three of his beneficiaries had died, and then there had been a corporation set up in those 2 years. So a lot of things have happened. Fortunately, the court said, "Oh, wait a second. Notice was given appropriately. The child was unknown to any of the family members. There was no way they could have known what was going on. And so we are going to uphold the probate, and we aren't going to change and have you undo everything and transfer it to this unknown child." But again, that's just the importance of providing notice. So under KSA 58A18, you probably see these, like if you open the newspaper, um, you'll see that there is a notice that's saying, hey, creditors have claims, and you've got 4 months from the date that notice is published when you're dealing with a trust to make a claim. However, if we do know of a creditor, we need to give that creditor notice, and that creditor has 30 days to respond and request to be paid. But the same would apply to unknown heirs. So in the Solzman case, if we had a trust, as long as we made that publication, and then she had not raised her hand, we would have been able to again bar her from trying to receive resources. The other thing I do want to go back to the Solzman case for a minute because you'll notice he went through the probate process. If he had had a trust that had specifically detailed his wishes and who he wanted his resources to, and everything was put into the trust, he would have never ended up in probate. And so the likelihood of that child, that alleged unknown heir showing up and making a claim would have, there would have just been that additional barrier. So the other hidden danger when dealing with creditors is that the state of Kansas has a specific order that creditors get paid in. The first is appropriate funeral homes, or yeah, funeral expenses as reasonably necessary. I've never seen anybody say that funeral home or funeral expenses are somehow unnecessary. Um, but we're seeing $15,000 for a funeral is not unusual. The second entity that gets paid is Medicaid or estate recovery. The third is the cost administration, so that's filing taxes, attorneys, those fourth, those ideas. Fourth is court judgments against the person that was deceased, and then fifth, every other demand, and then last is beneficiaries. Now that's for revocable trusts. Irrevocable trusts play by some different rules, and we're not going to talk about irrevocable trust rules today. Right now, we're just focused on revocable trusts, than the most applicable and most likely um, trust administration process. So, and then the IRS, and this is where you're gonna run into some time frame issues. So the IRS, there will need to be a final tax return for the settlor or the grantor, the person that passed away. Okay. There will probably need to be a file tax return for the trust. And then also we really need to get appraisals of real property. And the reason that we get appraisals of real property is because upon somebody's death, they generally get what's called a step up in basis. What that means is if their heirs decide to sell real property, stocks, real estate, those types of things, that reduces the amount of capital gains taxes that the beneficiaries would have to pay. So the other thing you need to know then is that sometimes it takes a little time to fully complete the trust administration process, and it's not due to anything the trustee has done or not done. It's just that there needs to have that final tax return filed. And that final tax return, so all of the administrations that I'm doing right now in 2024 can't completely be over until after that final tax return is filed in 2025 for tax year 2024. And we'll talk about how we work through that here in a minute. So if I have a family member who passes away here in December or in January, we may be able to get things distributed out and pretty much done in 2025, but it's still going to be till 2026 because of that final tax return that's got to get filed. So those are some of the hidden dangers with the IRS. The next big hidden danger is estate recovery. And so this really applies to people who have been on Medicaid and their resources may be subject to estate recovery to get paid back to the state. And we deal with a lot of families who utilize Medicaid to help pay for nursing home care because it does cost. I was looking up today, Kansas, the average is about $7,400 a month for nursing home care. I know that our Wichita clients, you can see $10,000 to $12,000 really easily. There is a place in Kansas City that it is $30,000 a month for care. Uh, high level of care, great place to be, but that's the expense. So what you need to know though is that if estate recovery is a part of it, estate recovery is going to send out a letter, and we'll talk about what's in that letter, but that there are ways that we can use some of the beneficiary situations to offset estate recovery and payback provisions. And so, how to offset that. And we also need to know that estate recovery has 1 year from the date of death to file a lien against real property. So let's kind of just unpack each one of those. So the letter. If someone has been on Medicaid, and if you have a family member that has a trust and that person's not on Medicaid, you don't need to pay attention to this part. But if you're worried about Medicaid and estate recovery, this is really, really important. So Medicaid sends a letter asking what resources someone owns at death. However, what I have to tell our family members is, our families is, they don't have any obligation at this point. There's no legal obligation to respond to that letter. I've had some family members respond to that letter. I've had some families, not give us a call when that letter happens. Most of the time, folks give us a call, but every now and then they don't. And so what estate recovery doing is they're just fishing. They're trying to find information. Like I said, there's no legal obligation to respond to that letter, at least at this point. Again, though, let's say we get that letter. We know that there is potential for a lien out there. In this case, we had a mother. She passed away owning a house. The house was given to her two children. Those children were disabled. Because they were disabled, estate recovery cannot come after those children and after that house. The idea being that we want those children to have a place that they can live, so that that reduces again the cost to everybody else for caring for those folks. Now, we had to provide proper documentation to estate recovery. They had filed a lien, but as soon as we provided that proper documentation to them, they released the lien, and that house is in those two disabled children's names and isn't going to be subject to estate recovery. Similarly, in a different case, we had a farm family that might have been subject to estate recovery. During the trust administration process, we learned that the mother had long-term care insurance, and that long-term care insurance was paying about $150 a day. Nursing home cost was about $210 a day. So we basically showed them, hey, here's the payment from the long-term care insurance. And for every dollar that long-term care insurance pay, it reduced that estate recovery claim. So we had at the beginning like a $70,000 estate recovery claim. Found out the long-term care insurance had paid $40,000. And we reduced that claim to about $30,000, and we negotiated some, so it was even less than that. And so looking for those offsets as you're going through that is really important when dealing with estate recovery and trying to, reduce the amount that gets paid back to the state, because there are some ways that can do it. So now that we've we've talked about keeping beneficiaries informed. We've talked about some of the hidden dangers with the IRS, estate recovery. This is everybody's. Um, this is with everybody's. Um, you know, Fun time, and that's when is the right time to make distributions. And Garvey brought up a question a few minutes ago that I didn't notice, saying that he thought with a trust you didn't have to publish notice in the newspaper, only with a will. And that's you don't have to publish notice with a trust. What the notice does is it just cuts off those creditor claims or those unknown heir claims. And so we end up publishing lots of notice. I see that it's like an insurance policy that we can bring back. It's fairly inexpensive to cut off those claims. So, for example, it's the I just lost the case name, but it's a case out of Kansas City where the trust published notice in the newspaper. Trust also gave notice directly to Medicaid, because Medicaid was one of the claimants. Medicaid had 4 months to make a claim. It actually didn't file a probate or a creditor's claim. It kind of contacted the trustee a little bit, but really didn't make a formal claim. And the court said, hey, you got notice directly to you. Notice was published. 4 months went by. Again, creditor period from notice, 30 days after the last known notice, 30 days after last known notice, and then there's also a 6-month period. And the court said, because all those time frames went by, Medicaid, sorry, you can't recover. So we do publish notice, but again, it's just notice 3 times. That starts that 4-month clock running. And then the other piece about that is that many times we wait, or we talk to the trustees about waiting till we get past that 4-month period before we make distributions. Again, the idea is probably aren't going to be any creditors out there we don't know about, but it's better to just be a little bit patient rather than rush it. Additionally, during that 4-month creditor period, we're probably getting appraisals of real property. We may be selling things. We may be making claims for life insurance. We may be setting up IRAs and making sure we know how those things are going to work. So really, there's a lot that happens in that 4-month creditor period. About month 3 after that is when people kind of start wondering, okay, where are things at and what's going on? And that's why we set up about every 6 weeks, we're just meeting with people just to make sure that everybody's being kept in the loop, that we talk with folks, we can keep that process going. So again, Some of the time frames, got your 4 month creditor period or 30 days after notice to last known creditor. And then what the statute says is that uh, um, if you provide a letter or a formal distribution plan to the beneficiaries, you provide the copy of the trust, you provide an inventory to evaluate at the date of death, provide an accounting showing the income and the expenses of the trust, and you show a distribution plan that is in accordance with the trust. You give those beneficiaries notice. They have 30 days to raise their hand and say, hey, we don't like this, we object to this. If they object within those 30 days, then we would answer their objections and start that distribution process over again. But if they don't, then they have lost their ability to object to whatever happened during that administration, as long as you provide a copy of the statute. Again, that in some cases we use that because I've got 7 to 13 different beneficiaries and trying to get them to and trying to get them to uh, you know, sign off on everything can be just a challenge. So we send out the distribution letter and that plan and see if we do have objections. The other option is you can ask for approval for the inventory, the accounting, and the distribution plan to speed up the process. So I was working with a family, and they did have about 6 folks or 6 beneficiaries, but they were all fairly local, fairly close. So we just set a time down at the end of the trust administration process. We had provided them inventories and updates about how things were going as the process went forward. And then it was very easy then at that meeting to just say, okay, hey, these are the distributions we want to make to folks. And if you will, waive this 30-day time frame, you can see how everything matches up with the trust. We can go ahead and make distributions. If you don't want to waive that, that's fine. Here's a distribution plan. We can wait 30 days and go that. But everybody was more than happy to say, okay, yeah, we're on board. We're going to waive that 30-day requirement. We were able to speed up that process. So you guys are probably wondering, since we're getting to the end of the year, okay, we're making distributions, but wait, what about taxes? Fortunately, and paying for the tax preparation, right? So we are here at the end of the year. I'm working with a lot of our trustees to try and get things wrapped up so we can get the final tax return done. The statute allows us to keep reserve funds in an account pending that final tax return, and then just have those funds made pay or paid out to the beneficiaries. So within all the distribution plans we have, we usually keep some reserve funds until after the filing of that last tax return. So that last tax return is filed, then the rest of those funds. And the amounts vary, it could be as little as $5,000. It could be as much as, 70, $100,000. It just kind of depends on what's going on with that trust administration, what kind of resources they are. One, we're holding back some additional funds because there's some real estate, so we just want to make sure we have sufficient funds in case something happens with that before it gets sold. So, um, that is a very, very broad, very quick overview of the trust administration process. And again, some of you, we've been working with this. Some of the folks I know out there, we will be working with your families on this. Many of you have already done this, but my suggestion is to schedule a strategy session if you're going to be a trustee or a fiduciary. What we normally do when we discover that one of the families that we worked with has had someone who's passed away, that we send out a checklist or hey, here are the things that you need to do. And one of those is to sit down and, meet with an attorney. That can be us, that can be somebody else. But what we find is the longer you wait to get the trust administration process started, the longer that administration may be. And that you need to know that you don't have to do it alone. There is a process, and we can work through that process and the solution. So this is what one of our family members said about working with us through that process. I think / know they have done a super job at taking care of all my business for me. They're none better. You guys are the best at what you do. I appreciate everything you have done for me. Um, so far, I think you've discovered the importance of keeping beneficiaries appropriately informed, a little bit how to do that as far as providing the copies of the trust, providing inventories at the day of death, ongoing accountings, some of the hidden dangers when dealing with creditors, including the IRS and Medicaid, and just making sure that when a creditor raises its hand or reaches out to contact a trustee, how do we work through that? We need to establish its appropriate claim. Whether or not we give information back to the IRS and Medicaid is different on a case by case basis. Talked about about the right time to make distributions of resources, but to hold things in reserve pending that final tax return, and hope you found how a trusted guide can help you, work through this process and work your families through this process. And so I know we've gone through a lot of information in a really short period of time, but I want you to get one thing. Following the process with a trusted guide generally allows a smoother transition while maintaining family relationships. So right now we're working with a family who put together a trust with us. There's quite a bit of farm ground. We have gone through, we started that earlier this summer. We've gone through and gotten the inventories with them. We worked with them on the accounting. We've talked about ways to distribute those resources to meet that family's needs. And so fortunately that farm is going to stay in the family, and the farm that's a part of it, the children are going to remain business partners, at least over the next little bit. So if you do want to know or want to have more conversations about how this process can go well for you and your family, um, then you can just give us a call, schedule a 60 to 90-minute strategy session. That may be in person, by Zoom, by telephone. At that point, we're going to discuss your family's resources, your unique situation. And many of you have been through this. If you've already worked with our office to do your estate planning, review your family's documents, or if you have them or no documents, establish your goals, discuss tax consequences, and then we'll talk about the unique situations that might rise in your family. At the end of our time together, and I know that again, a lot of you we've talked with, you'll know what the issues are that you and your family might be facing. Find out your goals, how to reach those goals. We'll talk about the responsibilities of being a trustee, what that means, who that person should be. We can develop a plan for a person's role as a trustee and how to set that person up for success. You'll know what kind of documents, other tools, how resources need to be titled to make sure that they are go through the trust administration process and not through probate. And again, we'll have a blueprint to administer the trust. That starts with getting your planning done beforehand, but then making it easy and seeing that plan come to fruition after somebody's death. So we calculated this up. The total value of this is $1,000 by the time we sit down with you, really take a good long look at your resources, put together that plan and send it out to you. But if you book your strategy session today, it's going to be a free consultation, so that we can talk with you, talk with your family members, whoever you want to be or whoever you feel it's necessary, helpful to have as part of the decision-making process of who those trustees need to be, how those resources are going to be distributed. And, Emily always thinks I'm crazy to give away these strategy sessions. And for years, she has tried to tell me we need to charge for these things. But I say, you know what? These families are coming out here to meet with us. That's the least we can do for them. You guys might think that just sounds way too good. So what's the catch? And there is a catch, and it's legitimate. We have a system. We have a system that we have used for years and that we continue to tweak and implement to make sure that all the estate planning pieces are in place and all of the I's are dotted and our T's are crossed. And we just ask that the families that we work with go through that system because we know it worked. It's worked for thousands of families, and that system can work for you too. So if you do want to book that free strategy session, you can call us. There's our number. Emily's going to be sending out an email after this webinar with a Survey Monkey that you can click on. You can fill that out. I do guarantee that you'll know more than you did before today. We'll talk about an analysis of what happens if you do nothing. So if you don't do any pre-planning, what does probate look like? We didn't talk about probate today because that's not what this is about. This is about trust administration, and we are avoiding probate. Um, and I hope you'll find that there are options available to guide and protect you and your family, which is the most important. And I promise you, your time's not going to be wasted talking with us and getting that in-depth look. So if you do want your free strategy session, again, you can call the number, click the Survey Monkey in your follow-up email. Um, it's about 12:45. So I've left some time to answer questions. I'm going to leave the free strategy session and the phone number up there so that if you do need that, you can get that. Emily, do we have any other questions in the chat box, or if there aren't any, does anybody, feel free to add any questions you might have.
Yes, it does look, I don't think that you covered this one, but yes, we would encourage now's the time to ask your final questions in the chat box. But Adam, what can you do if beneficiaries are unhappy that they were not chosen as trustee and even how the trust was set up?
Boy, so we don't really work with um, beneficiaries or how, we're not chosen as a trustee, and even how that trust was set up. Um, you know, the way that I receive resources transferred from one generation to the next is really a gift. And the grantors, the settlers, the beneficiaries, they're making a gift. They're making a choice. And so our job as or the way that I view it is our job is to fulfill what the intent of the grantors and what they were trying to do. Um, that can be tough. That can be a hard job sometimes. Um, but that's what we can do. But that's kind of where that's at. So
Okay. Thank you for covering that. I don't see any additional questions in the chat box right now, but please feel free to add your question now as we wrap up. Just to remind everyone, you will receive that follow-up email that Adam mentioned that will contain a recording of this session. That way you can share it with family members, friends, coworkers, or just go back and take notes on the things that Adam covered today. And then also that email will have the SurveyMonkey link. I did also put that in the chat box since we're booking pretty far out right now. So if you want the opportunity, you really need to reach out now because we
yeah.
are looking into January and February. So encourage everybody to reach out and get a hold of us that way as soon as possible. Feel free to call that phone number on the screen if you have any questions at all after about how the strategy session works or about any of the content that Adam talked about today. I don't see any additional questions, so we're going to go ahead and thank you all for your time today. And thank you, Adam, for sharing all that great information. And please reach out if you have any questions. Thanks, everyone.
Thanks, everyone.